All right, welcome back, y'all. This is going to be the final unit in a final lecture for Unit 3. This is the marriage and family section. So, our first case, a couple of these cases revolve around homosexuality. So, the first case is Bowers v. Hardwick, 1986, excuse me. This is a pretty criticized case. All right, the vote is 5-4 reversal of the lower court ruling, and Justice White delivers the majority opinion. And he says the issue presented is whether the federal constitution confers a fundamental right upon homosexuals to engage in sodomy and hence invalidates the laws of the many states that still make such conduct illegal and have done so for a very long time. Even if the conduct at issue here is not a fundamental right, respondent asserts that there must be a rational basis for the law and that there is none in this case other than the presumed belief of a majority of the electorate in Georgia that homosexual sodomy is immoral and unacceptable. This is said to be an inadequate rationale to support the law. The law, however, is constantly based on notions of morality, and if all laws representing essentially moral choices are to be invalidated under the Due Process Clause, the courts will be very busy indeed. Even respondent makes no such claim, but insists that majority sentiments about the morality of homosexuality should be declared inadequate. We do not agree and are unpersuaded that the sodomy laws of some 25 states should be invalidated on this basis. So they're saying we're going to leave it with the state courts. If you want to make sodomy illegal, we're leaving it with the courts in the states. All right. 2003, Lawrence v. Texas. So this is overturns the Bowers ruling. This is a 6-3 reversal, and Justice Kennedy delivers the majority opinion. And basically, Texas has anti-sodomy and anti-homosexual laws. And the questions presented in this case are, first, do anti-sodomy laws for men by not heterosexual couples violate the Due Process Clause of the 14th Amendment? Second, does criminal convictions for adult consensual sexual intimacy in the home violate their vital interests in liberty and privacy protected by the Due Process Clause of the 14th Amendment? And three, should Bowers v. Hardwick from 86 be overturned? So, first, the court points to precedents concerning the 14th Amendment. Griswold, like we read, gave all couples the right to privacy, and then Eisenstadt extended this to all women, right? You didn't have to be married under the 14th Amendment Due Process Clause. They later go on to say, if protected conduct is made criminal and the law which does so remains unexamined for its substantive validity, its stigma, right, might remain, even if it were not enforceable as drawn for equal protection reasons. When homosexual conduct is made criminal by the law of the state, that declaration in and of itself is an invitation to subject homosexual persons to discrimination, both in public and private spheres. The central holding of Bowers has been brought into question by this case, and it should be addressed. Its continuance as precedence demeans the lives of homosexual persons. Furthermore, the rationale of Bowers does not withstand careful analysis. Bowers was not correct when it decided, and it is not correct today. It ought not to remain binding precedent. Bowers should be, and now is, overruled. The case does involve two adults who, with full and mutual consent from each other, engaged in sexual practices common to a homosexual lifestyle. The petitioners are entitled to respect for their private lives. The state cannot demean their existence or control their destiny by making their private sexual conducts a crime. Their right to liberty under the Due Process Clause gives them the full right to engage in their conduct without intervention of the government. It is a promise of the Constitution that there is a realm of personal liberty which the government may not enter, citing the Casey case from 1992. The Texas statute furthers no legitimate state interest which can justify its intrusion into the personal and private life of the individual. So, states can no longer litigate homosexual acts. Okay, Case 3, U.S. v. Windsor. This is a 5-4 affirmation of the lower court ruling, and Justice Kennedy delivers the majority opinion. So, Windsor and Spire were a lesbian couple who married in Canada, and then moved back to New York before New York had legalized homosexual marriage. Spire died and left Windsor her estate. And when Windsor tried to use the estate tax exemption for surviving spouses, she was denied under the DOMA ruling, the Federal Defense of Marriage Act, DOMA, which was passed by the Clintons in 92 or 93, which refused to recognize same-sex couples as married. The lower court of New York basically told the federal government to pay back her taxes, and the Supreme Court agrees. And they make a 14th and 5th Amendment due process clause argument yet again. The Attorney General decided that they would not support the case in the Supreme Court against Windsor either. So the federal government declined to litigate. Basically, by this time, 11 states and the District of Columbia had legalized marriage, and the federal government was telling New York that the federal law superseded their own and that those marriages did not count. And the court says, by its recognition of the validity of same-sex marriages performed in other jurisdictions, and then by authorizing same-sex unions and same-sex marriages, New York sought to give further protection and dignity to that bond. For same-sex couples who wish to be married, the state acted to give their lawful conduct a lawful status. This status is a far-reaching legal acknowledgement of the intimate relationship between two people, a relationship deemed by the state worthy of dignity in the community equal with all other marriages. It reflects both the community's considered perspective on the historical roots of the institution of marriage and its evolving understanding of the meaning of equality. And so basically, the Supreme Court says that the federal government, the DOMA ruling, is a violation of due process and equal protection laws. And they say the particular case at hand concerns the estate tax, but DOMA is more than a simple determination of what should or should not be allowed as an estate tax refund. Among the over 1,000 statutes and numerous federal regulations that DOMA controls are laws pertaining to Social Security, housing, taxes, criminal sanctions, copyrights, and veterans' benefits. DOMA's principal effect is to identify a subset of state-sanctioned marriages and make them unequal. The principal purpose is to impose inequality. So DOMA's got to go. All right, case 4, Obergefell v. Hodges, where the Supreme Court legalizes gay marriage. So this is a 5-4 reversal of a lower court opinion, and Justice Kennedy delivers the majority opinion. This suit was brought by multiple couples across multiple states that had legalized marriage by this time. However, other states did not recognize these marriages, especially in the South. And so a suit was filed under the 14th Amendment Due Process Clause, and there are two questions to be answered in the case. First, does the 14th Amendment require a state to license a marriage between two people of the same sex? And second, does the 14th Amendment require a state to recognize a same-sex marriage licensed and performed in a state which does not grant that right? So if you're Texas or, Alabama, not only do you have to marry gay citizens, is one of the questions, but do you have to accept the marriages of those states that do allow homosexual marriage is the second question. Okay, and Kennedy goes on and he says, the nature of injustice is that we may not always see it in our own times. The generations that wrote and ratified the Bill of Rights and the 14th Amendment did not presume to know the extent of freedom in all its dimensions, and so they entrusted to future generations a charter protecting the right of all persons to enjoy liberty as we learn its meaning. When new insights revealed discord between the Constitution's central protections and a received legal stricture, a claim to liberty must be addressed. First, the right to marry. Applying these established tenets, the court has long held the right to marry is protected by the Constitution. In Loving v. Virginia in 1967, which invalidated bans on interracial unions, a unanimous court held marriage is, quote, one of the vital personal rights essential to the orderly pursuit of happiness by free men. Number two, marriage is an important institution that encompasses much of life, and the court already ruled that private homosexual behavior cannot be legislated. Number three, it gives meaning to the children and families of homosexuals and the legal protections necessary. And finally, they close by saying the court, in this decision, holds same sex couples may exercise the fundamental right to marry in all states. It follows that the court also must hold, and it now does hold, that there is no lawful basis for a state to refuse to recognize a lawful same sex marriage performed in another state on the ground of its same sex character. All right, that's the end of Unit 3. Thanks, you all, for being here, and I'll see you for the next unit. Have a great day.